Here we go again, an IR35 planning refresh. Welcome. My name's Fiona Herrell. I'm a partner in the Employment and Immigration team at Brodie's, and I'm delighted to be joined today by Karen Davidson, a partner in our corporate tax and incentive session. We only have a 30-minute slot for today, and as you will appreciate, there's quite a lot of material to cover. So what we've decided to do is not look at the current IR35 regime in any detail. We will refer to it, but we're not going to take you through in detail how the current regime works, but rather focus on the new regime that's going to be in operation in the private sector with effect from the 6th of April. And in particular, we're going to pull out three key themes: audit, undertaking IR35 assessments, and the disputes process, and some practical considerations arising from that. Now, for those of you who don't have an IR35 countdown sitting on your computer or on your desktop, I can tell you that the 6th of April is 11 weeks today. So that is the time period in which we've got left to get ready for the new changes. So with that being said, I'll pass over to Karen, who'll get us started.
Thanks, Fiona. So just very briefly, a couple of pictorials on how the current regime works for medium and large private businesses in the private sector, and then we'll look at how that's going to change. So the main thrust of the new regime is to try and capture a loss of tax which has been arising as a result of HMRC's perception of non-compliance of existing IR35 legislation by workers and their personal service companies, which we're going to call PSCs for the purposes of this. The obligation to assess employment status and operate payroll deductions currently sits with the worker's personal service company. And this model's been a relatively straightforward way for clients to manage their risk historically. If we move on to the next slide, you'll see how that's going to change for medium and large clients from the 6th of April this year. So where a client engages directly with the worker's PSC, so the picture on the left there, the client is going to need to both assess employment status for tax purposes, and also if the worker is deemed to be an employee for tax purposes as a result of that status assessment, the client is also going to need to operate payroll deductions for that worker. In a more complicated chain, which involves other entities or employment businesses, such as the picture on the right, which may indeed have any number of third parties in the middle there, the obligation to assess status is going to sit with the client, but the obligation to operate the payroll deductions is going to fall to the entity which pays the PSC, and that entity is called the fee payer for the purposes of the new legislation. So in a scenario where there's more than one third party, it'll be the third party that just sits directly above that PSC that is going to have the obligation to make the payroll deductions if the client assesses that that individual is inside IR35 or a deemed employee for tax purposes. On the next slide, we're going to just look briefly at what is considered to be a medium and large enterprise. Effectively, a medium and large enterprise for the purposes of the legislation is anything that's not a small enterprise. So when we're looking at that for companies, it's effectively a small company is going to be what is a small company for the Small Companies Regime in the Companies Act 2006. And it's going to be any company that falls within two or more of the following tests, or the tests that are on the slide there, will be a small company. If you're not a small company, then you're medium and large, and you're going to have to operate this legislation. There are some special rules that you need to look at for the purposes of non-corporate vehicles, such as partnerships, so worth bearing in mind that they are still potentially caught. It's just you need to look at a slightly different test. I guess it's also worth pointing out that where you have a group, you can't just look at each subsidiary in the group in isolation to determine whether they're a medium or a large enterprise. You need to measure it on a group basis. And if the parent is medium and large, then every subsidiary in that group is going to be medium and large for the purposes of the legislation and will need to operate the new rules. And I suppose worth also pointing out that it is the client size which is relevant. So any number of third parties in the chain that we were looking at earlier. It doesn't matter what size they are. It doesn't matter, obviously, what size the personal service company is. It's the client size which is relevant. Just before we move on to the next slide, I think worth also pointing out that a UK connection is required. So that means, for purposes of looking at the client, if the client has a UK tax residence or a permanent establishment in the UK, it will be COT. If not, they don't need to operate the legislation. There are slightly different rules for NI purposes. And similarly, where the worker wouldn't be subject to UK income tax on its employment income, then it would not be covered by the legislation and therefore no need to operate the rules. So a non-UK resident, which is not carrying out duties in the UK, will be outside of the regime. Sorry, just before we move on to that slide, I think it's possibly worth pointing out as well that if you do fall within the small companies regime, so you don't need to worry about the new regime if you're a client, the worker still needs to operate the current IR35 rules and apply tax to its PSC. So on to the next slide. What is a PSC or an intermediary for the purposes of the legislation? Because it's only where there is one of those that this new legislation will apply. If a client is directly engaging with a contractor who is an individual, then this legislation does not actually apply, but there ought already to be an assessment procedure in place to work out whether the client ought to be deducting PAYE from payments. So when we're looking at whether there is a PSC in the chain, there are a number of different intermediaries which are included in the definition. It covers companies broadly where the worker has a material interest in that, and there are a number of 5% tests that you would look at. Or where the worker doesn't have a material interest but is entitled to what's called a chain payment, which is a payment which relates only to the services which are being provided to the client. There are some tests also for the alternative models of partnerships, and also where there's an individual in the chain as well, that also counts as a PSC. Now, you might be thinking, if you're a client, how on earth am I going to be able to tell whether an entity that is part of the contractual chain is or isn't the worker's PSC? And it is going to be practically impossible for a client to be able to determine that. And so I think worth pointing out that it is the obligation of the worker to notify the fee payer whether or not there is a PSC in the chain. But if they don't do that and you don't get a definitive answer from the worker, you have to assume that the legislation is actually going to apply.
So if you're thinking about where to start, if you're within a business that hasn't started planning for the changes in the legislation, or if you have but just want to make sure that you've done what you are needing to do in order to get ready, we're proposing that the best place to start is really with an audit. And insofar as the contractor population is concerned, what you're trying to do is to, first of all, identify all contractors within your business. And I think that sounds like a very simple task, but for those of you who've already done it or who are partway through doing it, you will well know now that actually that can be much more trickier in practice. And particularly if you're within an organisation where there's more than one route by which contractors come into the organisation. So we know that some businesses will have contractors who come in through an HR route, but they possibly also come in through supply chain or procurement as well. And so there's no one route into the business that can easily be checked. So that is a task in itself, just to identify all of those contractors. And what you're then needing to do once you've identified them is to flag those who require assessing. So those who are engaged through an intermediary, as Karen said, and will be providing services to you on or after the 6th of April 2021, so within the scope of the new regime. If they are providing services through an intermediary, also be thinking about whether there is that chain that Karen identified in the earlier slide. And that will be relevant if you're going to have to go out and request information in order to be able to undertake your determination assessment, because it might not be that you're asking the PSC to provide that information direct, but rather you're going via an agency in order to get that information. Whilst you're building this picture of the contractor population, you're also thinking things like who the contractors are, where they sit within the business and what it is that they do. And that is all going to help you to form a picture as to whether what they are doing or whether that individual contractor is business critical to the organisation itself or to the particular project that they're working on. And that's really important to identify from the outset, because let's face it, things are changing, and ultimately you may well get to a situation where you undertake the assessment, you determine that the individual is within IR35, which means that you're not going to be able to continue to engage them in the way that you currently do, and you want to have a conversation with them about that. If you're not able to reach agreement with them, that individual may well stop providing services to you, and you want to be aware from the outset as to what that would mean for your particular organisation or for the project that they're delivering, and whether there could be repercussions in terms of late penalty fees, for example. Now, you might be thinking, well, that's okay, we've already done this step, we've ticked this box, and we did this in preparation for the changes coming into force in April last year, so we're ahead of the game on this. That's great if you're in that position, but we just remind you that actually you may well find that the position has changed since the last time that you did the exercise. There may well be new contractors who've joined your business or who are currently engaged to provide services to your business who weren't engaged at the time that you last did the exercise. So it is worth going back and just double checking if there are individuals that fall into that category.
Okay, so there are also, as part of your audit, you're going to need to look at some contractual chains to identify whether there are any additional risks associated with that, or whether indeed you can get comfortable that something's going to fall outside the regime. As I mentioned in a previous slide, where the client is not the one that's engaging directly with the worker's PSC, the obligation to actually operate the payroll deductions sits with the fee payer and not with the client. So does that mean that the client is entirely off the hook in terms of the tax deductions? The answer is no, and there are two circumstances where that can flow back. The first is where the client hasn't actually met its obligations under the regime and has not taken reasonable care in making its status determination assessments. HMRC have given some guidance on what reasonable care means, but obviously that is open to interpretation. So there is obviously going to be some tension around the tax risk that's associated with making those status determinations. There is another scenario in which the tax can flow back to the client, and that is where there has been some default in meeting tax obligations by the fee payer. HMRC does have the power where the fee payer has defaulted in making its tax payments, and there's no reasonable prospect of HMRC being able to recover that, perhaps because that fee payer has gone bust, where they can actually ultimately look to the client to meet that tax. And that's obviously extremely concerning for a client who doesn't really have any control over what the fee payer is doing. HMRC have provided some guidance on when they'd expect to use that power. But although there are some examples which do include an element of collusion or avoidance of knowledge of anticipated non-compliance, HMRC's powers are not actually restricted to those scenarios. So that makes it extremely important for clients when they're carrying out their audit to really diligence who is in that contractual chain and how comfortable are you that those entities are going to be able to meet their payroll deductions, their payroll obligations, and actually that they do intend to operate the rules correctly. And it's also something which you want to bear in mind when you're either drafting amendments or creating new contracts with employment businesses that you might have within the chain. There are also a number of scenarios which actually sit outside of this new off-payroll regime, and as part of your audit process, it's worth reviewing whether any of these apply, because that can cut down the scope of your status assessment requirements. The first one is where a service is a genuinely contracted out service and so therefore doesn't fall within the regime at all. HMRC have provided some examples of what they consider to be a contracted out service. Some contracts quite clearly fall outside the scope of the regime, but there are a large number that kind of sit in more of a grey area. So as part of your audit, you want to be risk assessing whether you want to take the view that that sits outside the regime or whether you want to be making status assessments for those workers as well. You also want to make sure that where you are engaging with other entities in the chain, and there is a view taken that one person is the client and the other person is is contracting with the client, that you both agree who's the client for the purposes of this legislation. And that way each party is going to be clear on what its responsibilities actually are. So again, worth reviewing contracts to cover off this point. The legislation does not apply where workers are engaged directly, so not through a personal service company or intermediary, with an agency which is going to be falling within the agency tax legislation. And that's because the agency will already have an obligation to be making payroll deductions before it makes payments to workers. And similarly, where there's an umbrella arrangement which is already operating PAYE, then the new legislation shouldn't have to apply to that. So you can see as part of your audit that it's going to be really important for each client to understand what entities are actually in the chain and do a lot of diligence in terms of those entities to make sure it's comfortable with them being part of that contract regime. On the next slide, we're going to have a look at what you should be using for assessing status. And this is a matter of hot debate. Many organisations have gone out and either created their own tool or acquired a tool from a third party. But one option is to use the tool that's been made available by HMRC online called the Check Employment Status Rule, or CEST. One of the benefits of using that tool is that HMRC have said they will stand by the result, provided that the questions that it asks you have been answered correctly and without any manipulation in order to reach a particular result. So that's not quite a guarantee, but it can be helpful in trying to manage your risk. And even if you are using your own tool or a tool that you've acquired, it might be worth sense checking that in some situations against the CEST tool to see what HMRC's view would be if they were operating it. If you are going to use the CEST tool, or any tool in fact, make sure that you are using it in your organisation consistently. And make sure that it is actually taking into account what's actually happening on the ground, because it's what's happening on the ground rather than what it says in the contract, which actually will determine the CEST outcome. And also, it's important to note, as Fiona alluded to earlier, that it's possible status might change. There's often a change in the fact pattern of how an engagement is actually operating in practice. But it's worth ensuring that you're going to be doing continual audits. You need to decide what time periods to do those in, dependent on the facts of your organisation, but it's worth having a look at the CEST or whatever tool you're using on a relatively frequent basis. If we move on to the next slide, just a few points to highlight some of the areas where the CEST tool does kind of fall down a little bit. It doesn't cover all scenarios, so it won't be tailored to your particular sector or your particular organisation. So you need to make sure that it is actually going to work for your purposes and make any tweaks if you need to. The greatest criticism, I think, of the CEST tool that it doesn't actually include any consideration of the requirement for mutuality of obligation. That has been the subject of a lot of court cases. And I think it is fair to say that it is an obvious omission, but it's one which HMRC have intentionally omitted from the CEST tool because they take the view that once a worker has turned up in an engagement, at that point in time there is mutuality of obligation. You may or may not agree with that decision, but that is HMRC's view, so it's worth knowing that when you're going into it. And I think it's fair to say that it's a fairly blunt tool, but as we said, there are some benefits in using it. I think we'll move on to the next slide. So once you've actually decided what the status is going to be, you are required to issue what's called a status determination statement and provide that to the worker and to the next entity in your chain before payment is going to be made under the contract. The worker, before payment has been made, has an ability to object to that status determination. And of course, workers are well versed, because they've been working with IR35 rules for a long number of years, and workers are well versed in the tensions of the CEST tool and other assessment techniques. And so there may well be a fair bit of objection from your workforce or your kind of contractor population. If a worker does notify that they want to object, then the client has a period of 45 days in which to reconsider its assessment and then either issue evidence or a reasoned outcome of that review, or if it has changed its mind, an updated status determination statement. I think it is fair to say that it is relatively unlikely, unless a client has actually missed out a key bit of information in its assessment, that it will come up with a different answer as a result of that dispute resolution. But it does at least give the worker an opportunity to kind of put forward their concerns. But if the client comes back with the same answer the second time around, there isn't really anything a worker can do around that other than vote with their feet. And so if we just move on to the next slide.
So looking then at really what that means in terms of your IR35 step plan, we've obviously pulled out some of the aspects of the plans. We've talked a little bit about audit. In terms of preparing, one of the things we've not had time to talk about in this session, because it is a 30-minute session, is thinking about your hiring models for the future, analysing the cost implications of those, and then identifying risks of changing your hiring model. But that is absolutely crucial as part of you preparing for the changes coming into force. We could probably spend quite a lot of time just looking at the various different hiring models, but and the cost implications that go alongside each of those. But really what you're thinking about is, are you going to operate PAYE in respect of individuals who fall within IR35, and then do they get, are you going to give them some sort of employment rights to go alongside that? So are you going to perhaps look at an employment model, for example, and the costs that go alongside that, as well as, of course, the individuals having enhanced rights that they don't have as contractors? Or are you going to look at some of the other models, perhaps engaging agencies, for example, and having them enter into your chain if you don't currently have them at the moment? But that's definitely something that you're going to need to be doing if you've not started that process already. And as I said earlier, as part of your audit process, really thinking about those individuals who are business critical or project critical, and what the position will be if those individuals decide to cease providing services to your business because you can't reach agreement as to the way forward. I think everything else on that slide we sort of touched upon already, or will be fairly self-explanatory. So we'll then just move on to have a think about what you might want to have in your IR35 toolkit. In terms of your essentials, because obviously this is not just a static exercise or a one-off exercise, but as Karen said, it's something that will both need to be done on a regular basis in terms of your review of contractors who are in your business on an ongoing basis, but then also new contractors who are coming into the business after the 6th of April. So we're proposing that you think about having an off-payroll policy. And the idea behind the policy is really to set down clearly for your hiring managers within the business the circumstances within which individuals can be brought in to the organisation as a contractor or on an off-payroll basis. So as to try and reduce the likelihood of hiring managers coming and saying, I'd like to engage this individual as a contractor, please. And so, for example, what you might say in your policy is that you will not ordinarily consider a contractor for a role that has been identified as a permanent headcount staff role within the organisation, because it's been identified as a staff role and therefore not one where you would ordinarily consider a contractor, to try and avoid that situation where the line manager wants to bring a contractor into that role unless there are specific circumstances for doing so. And you might want to have a sort of decision tree or a flow chart that sort of sets out quite clearly the process that will be followed in terms of deciding whether or not somebody can be brought in as a contractor, and what the circumstances would look like, and what the process will be, and what the time period will be. And the reason for that is because what you want to try and avoid is, again, hiring managers going off out, having conversations with people, doing deals with them. Yes, that's great, we'll bring you on these terms, and then coming and saying, right, I've agreed that this person's coming in on these terms, and then as a business we have to say, no, actually that's not going to be possible because of the change of the rules, and actually this is what we need to be doing instead. If you're engaging with contractors and their PSCs directly, so without any sort of agency or other intermediary in the chain, then thinking about the contracts that you use with them, and in particular the terms that you've got in there in terms of provision of information and in terms of tax indemnity, well, tax arrangements and then tax indemnities, and what amendments need to be required. And similarly, if you do have employment businesses or agencies within your chain, then again looking at those contracts and the tweaks that would need to be made. A status determination statement that you can issue once your assessment has been undertaken. As Karen said, CEST produces one, or it might be that you want to create your own, but having a template that is within your toolkit that can be used will be necessary. And then possibly also a sort of Q&A for your engagement with contractors, so explaining the process that you have undertaken and the decisions that have been made and what the arrangements are going to be going forward, so that you've got a sort of central document that you can refer back to. In addition, you might want to be thinking about training for line managers, for example, or for those who are undertaking the assessment tool. As Karen said, it's important that assessment is done on a consistent basis. So if lots of different people are going to be involved in that, then you want to make sure that you're helping them to do that consistently. And so it might be that training is something that you want to roll out there. And then having some sort of process or procedure for your ongoing review and your reassessment. That might be that it sits within part of your policy, or it might be something that is standalone. We are just directing you to our IR35 hub, which is a space within our Brodies.com website, where we have published blogs and articles and the timeline and the step plan. So you might want to have a look at that, depending on where you are on your journey of getting ready for April. And that just leaves us with time for some questions.
Fiona, I'll pick up one that I think is to you. If a worker is deemed to be an employee for tax purposes, does that mean that they also have employment rights? A hot topic.
Hot topic. So the starting position is no, just the test and employment status for tax purposes is different as compared to for employment right purposes, and they don't necessarily follow each other. So just the simple fact that somebody has been determined to be an employee for tax purposes, and therefore within IR35, does not mean of itself that they automatically get employment rights, but it might be worth having a look at the way in which they're engaged and what it is that they're doing, and just double checking that we don't think that they would have either rights as a worker or indeed rights as an employee, employees having more rights than workers. So it won't necessarily follow it's automatic.
Okay, and I'll probably pick up this next one. If I have an engagement which has commenced before 6th of April, but payment is made after 6th of April, which regime will apply? The regime only applies in relation to the services that are provided after the 6th of April. So if, even though you have payment which is made after the 6th of April, if that relates to services which were provided prior to the new regime coming into place, then you don't need to operate payroll on that. However, if you've got an element of services being provided both before and after the 6th of April, which may well be the case given that payments don't tend to be made on the 6th of April, then you need to make a reasonable allocation of payment for both the pre and the post 6th of April period. So I think that probably covers off that question. And then there's another one here that talks about how I mentioned that substitution can be a tipping point for the CEST tool. And what does that really mean? Just a word of caution. So it does seem to tip the CEST tool one way, but there's a real word of caution on substitution being used in contracts simply as a ruse to try and get somebody outside of the IR35 or off payroll regime. And HMRC are alive to that, and they will question whether somebody in practice could send along a different worker to perform services under that engagement, and that would be accepted by the client, you know, in any circumstance. So there's definitely more to that question than meets the eye. So definitely proceed with caution if that's the only basis on which you're tipping that way.
So I'm conscious of the time, Karen, so I think we should probably wrap up there because it is 1 o'clock. Thank you all very much for joining the session. We hope you found it useful. We'd be grateful if you complete the feedback form. It's really important to us that we get your feedback in relation to the sessions that we are delivering, so please do that, and we'll take it on board. If there's anything that Karen or I could help you with in relation to your IR35 projects, then please do just get in touch with us. We're very happy to have a conversation with you offline about that. Thank you very much.